NHS Trust and others, and why?
Yes, Mr. Gordon, before you begin, of course, I'll remind everybody present that we've made a reporting restrictions order to protect the identity of those involved.
Thank you, my lady. My lady, may I first deal with representation? I appear for the appellant with my learned friend Ms. Fiona Patterson. The first and second respondents are represented by my learned friends Mr. Vikram Sachdeva and Ms. Catherine Dobson. There are written submissions in this case, and in one case, evidence from one of the interveners. And the submissions of the first and second interveners, the Intensive Care Society and the Faculty of Intensive Medicine, were prepared by my learned friends Mr. Alex Ruck-Keane and Ms. Annabel Lee. The submissions of the third interveners, the BMA, were prepared by my learned friend Ms. Katie Scott, and the submissions of the fourth interveners, Care Not Killing, were prepared by my learned friend Mr. Charles Foster. As far as the materials go before the court, there's a core bundle, there's an interveners bundle, there are 8 authorities bundles, and 2 supplemental bundles. There may, subject to how the case progresses in time, be one further bundle, but I won't deal with it now unless the court wishes me to. May I, because of time constraints, go straight to our 7 propositions, because I take it as read, but won't, if your ladyship tells me not to, that the court will be very familiar and will have read through both the legal framework and the facts.
Yes, indeed.
So we have 7 propositions on this difficult and sensitive issue. First of all, we submit that it is important to identify what the issue is, and it's a single issue. The central issue is whether the obtaining of an order from the Court of Protection before CANH, clinical assisted nutrition and hydration, may lawfully be withdrawn from a person with a prolonged disorder of consciousness, which I'll call PDOC in future, is unnecessary where a best interest judgment of the clinicians treating the patient has been made that continued administration of CANH is not in the patient's best interests, and, important proviso, the patient's family agree with that judgment. I'll come back to why I've spelled that central issue out in a moment. Our second proposition is that we say that unless the respondents succeed on the central issue, the learned judge, confronted as she was by an application for the broadest of declarations, and in the light of the way that the hearing progressed, could not confine the declaration that she granted to the facts of Mr. H.Y.'s case, and could not have made the declaration that she did. The third proposition is that unless the respondents succeed on the central issue, the declaration cannot be upheld because no best interest assessment was undertaken by the learned judge. The fourth proposition sets the scene for the last 3 and attempts a framework for the analysis that we respectfully submit this court should then engage in to determine the central issue. We say that the analysis of the central issue falls into resolving 3 questions. 1, do the provisions...
Is this all part of your fourth proposition?
This is all part of the fourth proposition because the 3 questions will then form propositions 5, 6, and 7. So, first question, do the provisions of the Mental Capacity Act exclude the application of such common law and/or fundamental rights protections as might otherwise exist? Second question, is there space for the application of common law and/or fundamental rights principles to ensure compulsory mechanisms for the protection of such rights, including those described as rules of practice? And finally, third question, on the fourth proposition, do PDOC cases fall into a special category such that there are compelling reasons for the application of such common law and/or fundamental rights protections as exist? And then the fifth, sixth, and seventh propositions are relatively easy because they purport to answer those questions. Proposition 5, we say that the provisions of the MCA do not exclude the application of separate and independent common law and/or fundamental rights protections if such protections exist. Sixth proposition, we say that common law, constitutional, and fundamental rights principles may require compulsory mechanisms to exist for the protection of such rights. We say that rules of practice, if they're sufficiently followed, robustly followed, are capable of providing those mechanisms. And seventhly and finally, we say that the withdrawal of CANH in PDOC cases is a special category of case that demands common law and fundamental rights protections to ensure that there is independent oversight of such cases by a court. This case, it is important to emphasize, is not about whether it is in a patient's best interests to have CANH withdrawn. It is about who decides that question. So may I turn then to the propositions in turn. First of all, identifying the central issue. We take it to be common ground, or at least implicit in the respondents' formulation of their case, that they do accept that some PDOC/CANH cases, withdrawal cases, must come before the court of protection. Equally to be implied is the sub silentio restriction that such cases are confined to a clinical evaluation of best interests, and that ultimately the clinicians will decide what is in the best interests of a particular patient. It then falls to the family, the relatives, to determine whether they agree with that best interest assessment. But the important point is this: whether one is concerned with a situation in which the family agrees with a particular evaluation of best interest by the doctors, or whether for some other reason the doctors consider that the case should come before the court, we are concerned solely with the arbiters of that question being the clinicians. Ultimately, the clinicians will be the trigger for a case coming or not coming before the court. What this means, therefore, is that any obligation, if the respondents accept that much, to bring such cases to court is in fact heavily, primarily dependent upon the judgment of the treating clinicians and any second medical opinion, rather than upon a court assessment. Now, that may be right or it may be wrong, but it is, we infer, the real issue here. However it's put, the respondent's submission that not all PDOC/CANH cases must be brought to court does not take them very far unless they go further and explain what is, in their submission, the class of such cases that does not need to be taken to court. And it will all ultimately reduce back into, because that is the logic of their case, the clinical judgment of the doctors. So that's the first proposition, to identify what the issue is. That brings me to the second and third issues, which relate to the judgment, the approach of the learned judge. So our second proposition, what was the judge's declaration in substance? Now, in substance, the respondents were quite open and identified the central issue in the breadth of the declaratory relief that they initially sought. And may I give you a reference? I know you will have picked this up immediately, but the claim form, Appendix Tab 7, memory stick pages 51 to 52, pages 51 to 52, and memory stick page 192, and paragraph 1 of the judgment, memory stick page 147. And the declaration sought was this, and I'll read it if I may. It is not mandatory to bring before the court the withdrawal of clinically assisted nutrition and hydration, CANH, from a patient who has a prolonged disorder of consciousness in circumstances where the clinical team and the patient's family are agreed that it is not in the patient's best interest to receive that treatment, and that no civil or criminal liability will result if CANH is withdrawn. That was the breadth of the declaration sought.
Is that an agreement? Is it that follows where they're agreed? That sounds rather odd.
Yeah, well, yes, absolutely. It's the proviso is that the patient's family are agreed. So
It does seem odd that there should be reference to an agreement by non-lawyers that no liability will result. Right. But the judge didn't have any truck with that last bit, did she?
No, not with the last bit, because the last bit is, even now, I would have thought, highly controversial.
I don't think it's pressed.
No, it's not.
No.
It is important to consider the aspect of criminal or civil liability, because when we come to cases like Bland, of course, that was the primary focus of those cases. But ultimately, there is quite a separate strand, which is that of protecting the patient. But anyway, that was
I think that actually, reading it here, it must refer back to seeks a declaration from the court that no civil or criminal liability will result. So if, in those circumstances, CANH is withdrawn, it's easy to misread it if you don't see the whole thing, but seeing the whole thing now.
Yes, absolutely.
Right, yeah.
But it's clear on its face, we say, from the breadth of that declaration, that the application raised a pure point of law, divorced from the facts of the individual case, but of generic application, provided that the facts of any case involved, first, the best interest judgment, and secondly, the agreement of the family with that judgment. It follows, we say, that if, as it did, the application succeeded, if the appellants succeeded on, if the claimants, as they were, succeeded on the central issue, there was no need for the court to have been involved at all, or therefore to have been required to examine the clinical diagnosis, or to have examined separately any question of what or was not in Mr. H.Y.'s best interests. That was the logic of the application. That the learned judge treated the application as one of pure law is absolutely clear from paragraph 21, Roman 3 of the judgment, memory stick page 150, and I'll read it if I may. The issue before this court is limited to the issue of law.
Is this contentious?
Well, in one sense it is contentious, and may I explain why it's contentious? Because what appears to be said both by the learned judge, I'll get to this in due course, and by my learned friend, is that we had the opportunity to look at medical reports, instruct our expert, and we chose not to do so. And that's what my learned friend Mr. Sachajeva says in his case, and it appears, you will see, in the reasoning in the judgment. Now, therefore, it's very important for me to stress that all that was before the learned judge was a pure point of law. And there was no question, and I'll come to this later when we come to Proposition 3, no question of the official solicitor, therefore, instructing experts or doing anything before that first hearing. That no legitimate criticism can possibly be levelled at him. But I just want to make it clear that paragraph 21, Roman 3, makes it abundantly clear that the learned judge was only dealing with a point of law. But having made that ruling and decided to determine the pure point of law being advanced and refusing the official solicitor's application for an adjournment, what the judge then did was to restrict the ambit of the declaration to the facts of Mr. H.Y.'s case. Now, I suppose there are 2 points in the way that the learned judge restricted the declaration. The first is the observation of my Lord Wilson that she did not record as any part of that declaration anything in relation to civil or criminal liability. But the second element of it is this, that rather than treating it as a generic application, she purported to restrict the grant of the declaration to the particular facts of a particular case. And with respect to the learned judge, we say that that was a distinction without a difference. And so, because of that, and because the official solicitor only participated in the case as a pure point of law, all that was left for the judge to do really, in our submission, was to strike out that very last bit of the declaration on liability, but to grant the declaration as sought, because she was granting a declaration not restricted to the facts of a particular case, but actually a generic declaration which closes off a whole range of cases, not just the case in front of her. And we say that the grant of a formally limited declaration did not and could not cure the logical vice that if the learned judge was not being asked to look at any facts, no declaration granted could be other than general in its effect. So that is proposition 2. What was the declaration actually granted? Proposition 3, again, can be dealt with quite shortly, because it inevitably follows, if we're right on proposition 2, as night follows day, that there was no best interest assessment by the court. At the heart of the judge's reasoning, we say, lay an incongruity, namely, that she reached conclusions on the basis of legal argument alone, as opposed to conducting any forensic assessment of Mr. Y's best interests, or indeed, as she was asked to do, transferring the case to the Court of Protection to be dealt with by a specialist judge. So, the difficulty we find with the way that the learned judge analysed the case is that she confused two different exercises in our respectful submission. Because she considered that she was determining a pure point of law, see again paragraph 21, Roman 3, she decided the case, as is absolutely clear from the judgment, without affording the official solicitor any opportunity to represent Mr. Y's interests. At the same time, however, she went on in paragraph 47 of the judgment, see memory stick page 157, page 16 of the judgment, to say this, and I quote, "Although the official solicitor had not carried out a full investigation into the case, there had been sufficient time for any concerns to be identified as to the process carried out by the Trust, any doubts as to the diagnosis or prognosis, and any further investigation that might be necessary, but none had been identified." Now, we respectfully submit that what that reflects is a confusion. It reflects a confusion that although she was determining a pure point of law, and the official solicitor was taking part on that basis, in some way there was a point to be made about the lack of investigation. My learned friend makes a similar point in his case, and it is, with respect, logically incoherent. So I'm not going to go into the detail of how long the official solicitor had, because it's analytically irrelevant, but I will just say this. This case, on such an important point, was dealt with by two technology and construction law judges, totally as a point of law in isolation, from any question of best interests. Had the learned judge been undertaking a best interest assessment, we say that her response to the official solicitor's submissions, that the application be adjourned, and Mr. Y's best interests in respect of the withdrawal of CANH be determined by a specialist judge of the Court of Protection, would almost inevitably have been different.
Mr. Gordon, we may very well ultimately agree that the amount of time the official solicitor had is irrelevant. Nevertheless, speaking for myself, I would be grateful to know when he was notified about this application, which was issued on Wednesday, 1st November, came before the directions judge Friday, 3rd November, and came before Mrs. Justice of Farrell Friday, 10 November.
He had 1 day's notice of the application.
1 day's notice?
Of the first application to Mr. Justice Fraser.
So you mean he was notified on Thursday, 2 November?
Whatever the date. I think the hearing was on the first of November.
1 November Wednesday is when the claim form was issued, and I believe that the directions were given on Friday, 3 November. So the question is, when?
He was notified on the 31st of October.
He was?
On the 31st of October.
Very well. Thank you.
So that's the precise chronology, my lord. And so we do, with respect, say that it follows that I mean, I come back to this point, having laid the ground for it in Proposition 1, that this is a case about a central issue of principle. Which takes me now into Proposition 4.
Well, it wouldn't be in this court if it weren't.
I know, but it's not so much that, my lady, as the earlier confusions that we say have...
Well, you say they're confusion.
I do, with respect, say they're confusions, yes. Proposition 4, what is the correct framework for analysing the central issue? And you have my suggested 3 questions, and they arise in part because of the approach taken by my learned friends to the application. So the first issue is whether the MCA containing statutory regime for the determination of best interests is incompatible with the existence of the common law and or the fundamental rights for which we contend. Now, we say that the MCA simply does not, on its face, exclude the existence of those rights. But my learned friends say that it does, so that is an issue in the case. And
can you just define the right? If you were seeking a declaration, what would it be? Would it be the precise reverse of the one the respondent sought and obtained, or would it be wider?
Well, we would be seeking a declaration. In a sense, I think your Lordship's right to implicitly to suggest that it would be wider, because, or as wide, because what we would be contending is that all these cases, PVS stroke, MCS, minimal state of consciousness, must be brought before a court. Or, let me put it this way, at least a neutral third party, an overseer such as the official solicitor, must be involved, must have the opportunity to investigate. Now, how you proceed after that is, in our submission, a question only of logistics, because there must, we say, to protect common law and or constitutional rights of the kind we advocate, a mechanism by which a potential dispute is capable of being identified and not excluded by the judgment of the treating clinicians. A potential dispute could be identified by the official solicitor. The official solicitor might say, on investigation, actually there is no dispute. Now, what should happen then? Either there should be some form of protocol explaining what should happen then, and the law should be clear. It might be that there wouldn't be a need for a court hearing in those circumstances. I suspect that the best, most principled answer would be that there could be effective case management of the kind that this court identified in the ACCG case in a different context, by which there could be a filtering system, and if there was effectively agreement on the part of the official solicitor, the case wouldn't, in substance, progress further. So in a sense, the answer to my Lord Mance's question is in part yes, in part no. It just depends what happens when the third party has the opportunity to investigate the particular case.
But it matters quite a lot whether the case has to become a case or whether it doesn't have to go to court at all. That matters a huge amount.
Yes.
Which of those two are you saying?
I would respectfully say that it doesn't have to go to court if, in certain circumstances. But the point is, what are those circumstances? And in our
If it doesn't have to go to court, how will case management arise at all?
Well, it will only arise, but let me put it this way. I thought I'd put it in 2 ways, and forgive me if I was loose in my response to my lords. There could be a very short-form court resolution in circumstances where the official solicitor agreed with the clinicians and identified the absence of any doubt.
So you're saying it does have to go to
No,
court?
I'm not.
It could be...
I'm sorry, my lady, I'm not saying that. What I'm saying is that could be one way of resolving the problem. Another way may be a declaration by this court. It doesn't need to go to court. Once you've got the third parties, you wouldn't need case management. I put forward the suggestion that a court resolution, even if it was the most perfunctory scrutiny might be the most principled way of dealing with it. But I don't think, and I certainly, unless I'm told otherwise, I'm not advancing a submission that it has to go to court, because a different way of dealing with it might be, and perhaps a more pragmatic way of dealing with it might be, that if the third party, in casu the official solicitor, said, there's no dispute here, whatever, we don't need to have any involvement of the court, that may be sufficient in convention stroke.
But we're now not arguing about a general principle, we're arguing about every single case and every single possible procedure, and your written cases simply haven't been directed to that, have they?
No.
I mean, are we to write a textbook on admissible procedures?
No, exactly. My lord, that was, in effect, what's behind my reluctance to attempt by submission to prescribe what should happen. The point I would make is this. It is not really for this court to lay down a template for what should happen.
But what do you want us to do?
What I'm asking your ladyship to do is to say that in order to protect a series of common law and convention rights, a neutral third party, and inevitably it will be the official solicitor.
Why inevitably
Well,
the official solicitor?
it's got to be somebody
Who's
outside the
solicitor?
family or the clinicians.
Who's going to fund the official solicitor to do this?
Well, my lady, at the moment we have a system whereby such cases come to court, or at least we had that system. That system may, in the future, have to go. But until a system is devised for protecting and continuing to protect the rights for which we contend, it should continue. That's the point. This isn't a binary answer. It's a question of what do you do in a situation where 20-odd years ago, these cases were given protection and required to go to court, and a situation in which it is now suggested there should be no protection in the form of third-party scrutiny. I am not attempting to make submissions to this court, certainly beyond my pay grade, as to the exact procedures that should happen. I think what I'm really saying is that this court should actually not interfere with the current process unless one is devised which protects those rights, and it would be open to this court, at least, to lay down authoritatively the kind of protections that it considered would be adequate. But I'm certainly not in a position to say to this court, what should happen is A, B, or C. What we do say is the present situation works. There may be imperfections in it. There may be resource problems with it. But the last thing that one wants to do is to throw the baby out with the bathwater and say, well, that there is simply no need for any form of protection of the kind that currently exists.
Mr. Gordon, can I just try and clarify my own thinking about this? You gave us a helpful route map at the start. But,
Yes.
It's a question of law first, isn't it?
Yes.
Does the law require these cases to go before the court? And you say, yes, it does?
Well, I say what the law requires is, in the absence of any other mechanism which protects common law and convention rights, all cases must go to court. But it may be that in the future, and this, after all, is exactly the way it was put in Bland, sufficient expertise is built up, maybe through protocols, maybe through a careful recitation of the circumstances in which a third party may come to act. But until that happens, we have a system of protection which is protecting such patients. So I repeat that I'm not trying to do anything other than to say that the essence of our case is that there must be a mechanism to protect these kinds of patients for the reasons I'll come to, and I'll identify what we say the various rights are. But it may not have to be provided one is devised, every case going to court.
And returning to the route map,
Yes.
I think it must be a necessary part of your case that the medical guidance is not sufficient as a protection.
Absolutely. Yeah, definitely.
But how can we say that? We haven't been asked in the cases to examine the current practice in detail. We haven't been asked to consider how far independent consultants are involved and whether they might not be an appropriate substitute for an outside third party, which you're urging, and so on. I mean, it seems to me that your criticism is really one which could only be made if we were satisfied that existing practice was completely unsatisfactory or unsatisfactory.
Well, I suppose it depends how you define the existing practice. We might have two different definitions.
Yes, quite. No, the existing
But
practice is go
existing
to court.
practice is that cases are brought to court.
Yes.
My point is very simple. We're not asking this court or your lordship to wade through the details of an alternative to going to court. Our case is that until the tectonic plates started shifting recently, all cases went to court. We don't even know how many PVS cases there are. We don't have the hard data, and I'll come to a sentence that makes that clear later. We know very little, and in the absence of knowledge, I would say two things. First of all, it's not for me, and probably with the greatest respect not for this court, to lay down as a matter of law what protections there should be, but it is for this court to lay down what the minimum protections there are should be.
What I had in mind by existing practice was the December 2017 guidance which followed Briggs, Riem and the present case. I see it says that final guidance is to be published in May 2018, but I assume that the December 2017 guidance is something one could look at and which is now being followed.
Well, I think the trouble with the interim guidance is that it sort of follows the case law. So it's almost pulling oneself up by one's bootstraps. It's saying, well, this is what the cases say. And the problem is, we say all those cases are wrong. That's the difficulty.
But it has protections in it, though, doesn't it? It doesn't have requirements for independent consultants or outside.
Yes, but the point really comes down to, and I'll come to this later again, but what one is looking at here is the case in which the diagnosis is not clear. There may be mistakes. We're talking about cases where the evaluation of best interests is very difficult. And that actually appears in the 2013 guidance, and again, I'm going to come to that. And we say there, you are dealing in those kinds of cases with an adjudicative difficulty that is only really properly to be tested by a court. There are some areas of evaluation which are within the province, obviously within the greater province of clinicians. There are others which are within the greater province of the court. There may be ways of isolating the number of cases which have to go to court. After all cases of doubt do have to go to court. I mean, that is undoubtedly the law. The question is, I come back to this question, what is doubt? Who determines? If you look at situation or scenario A, the family agree with the clinicians. No doubt. Why does the agreement of the family remove the existence of potential doubt? The family may agree for all sorts of reasons. The clinical diagnosis might fall to be tested. And some of the cases we'll show you are cases where the initial diagnosis was wrong, even by very leading experts in the field. It is axiomatic that the overlap, the trajectory, the transition between PVS and MCS can raise the most challenging questions of best interests evaluation. And so we said that if it's clear, objectively, that there is no doubt, and by objectively, I think this is the crux of our case, when a third party has looked at this, that's one thing, and that would, in fact, comply with convention, stroke, all common law requirements in my respectful submission. But we're talking about a very simple point here, and it's a difficult point. Who determines whether there's doubt? At the moment, it is a purely clinical evaluation supplemented by discussions with the family. Now, all I say is that I can't myself put forward as a series of propositions what a better procedure would be than the present one. But at least the present one does guard against these rights being overridden. But, sorry, I'm just going back to that first of the three questions. The first question was whether the MCA, containing as it does a statutory regime for the determination of best interests, is incompatible with the existence of the common law rights or fundamental rights for which we contend. Mr. Sachdeva says completely incompatible, because the MCA regime is a permissive regime. It provides for the evaluation of best interests by clinicians. Now, we simply say this. At this stage of the argument, I haven't even got to identifying the rights for which we say exist. But if those rights do exist, it is simply completely wrong to say that common law rights can't arise, because that stems from the common law principle of legality. Unless the Mental Capacity Act intends to abrogate such rights as exists, those rights exist. That's obviously a very simple statement. And you have to use the clearest of language in order to establish a statutory intention to abrogate rights. So we say that the first point of law on that first issue is absolutely clear. The second issue on proposition on proposition 6, I should say, is whether the common law or convention may, as a matter of law, require mechanisms to protect especially vulnerable groups of patient, even where the mechanisms that have hitherto existed have been described as rules of practice as opposed to rules of law. As to this, which I will come back to, what we say is that it is the substance rather than the form which dictates the nature of common law or convention protection. And the fact that applications to the court have been articulated in cases like Bland, and I think in REF as well, as rules of practice cannot affect the scope of common law or fundamental rights protections. We say that both the common law and the convention are relevant when it comes to considering the legal entitlements of patients in the position of Mr. Y. But I still have to, I think, get home on the third of these questions, which is proposition 7, whether PDOC patients from whom CANH is proposed to be withdrawn are indeed especially vulnerable so as to attract the protection of the common law or the convention. As to this, we say, come back to it at the last proposition, we say that such patients are in a particularly vulnerable position because of the combination of a number of factors that are not found in that combination in other cases. They include, 1, the dangers of misdiagnosis, 2, the challenging nature, I've mentioned this earlier, of the best interest decision, and as I've said, one more appropriately within the scope of judicial evaluation in many cases, particularly when confronting the transition between PVS and MCS. And thirdly, the fact that there is in such cases, the fact that there is in such cases clinical stability that is not present in the intensive care cases, or those cases in which, to cite from the BMA so-called third category of case, there is a downward trajectory. And 4, and not to be forgotten, the controversial nature of withdrawing CANH, where that's the link, the real link with potentially a long life. Many people see that as a component of basic care. when such withdrawal will curtail a life that might have lasted for many years. Now, in this last element, we accept that there is a link with moral perception. But as Bland appears to recognize, in this area of the law and morality are often linked. So we say when you look at those four combinations of factors, you reach a special position in the context of this kind of case, which definitely deserves special protection. Quite how you achieve that protection, and particularly where some of these cases will not necessarily be that difficult once they're scrutinized by a third party. But that's not really the question here. The question here is what deserves protection? And in our submission, these cases fall within that category. So that's proposition 4. That's the route map, or the suggested route map for analyzing this case. May I now turn to each of those in turn and come first of all to proposition 5, the MCA and the common law and the convention. And the respondents contend, see the respondent's case between paragraphs 105 to 108, that a common law rule is inconsistent with the provisions of the MCA. As we understand their submission, they do not contend that such obligation could not arise under the Human Rights Act, but they have separate submissions about that to the effect that the MCA regime is compliant with the provisions of the Human Rights Act. Now, we do not say, make this absolutely clear, we do not say that the MCA is incompatible with common law or convention rights. What we say is that it cannot be read as negating such rights as already exist, and can indeed be read entirely compatibly with those rights, only if the MCA contained, by express or necessary implication, an intention to abrogate those rights, could it be said to be incompatible with them. And so it follows, in our respectful submission, that the MCA regime does not of itself point to the presence or absence of relevant common law or convention rights. Now, I'll come back to paragraph 8.18 of the Code of Practice later, but that makes it clear that nothing in the MCA affects the decision in Bland. He says that virtually. But the principle that we rely upon is the common law principle of legality. And I can give you some references. I suspect that principle is so well known to this court that I need only cite a few cases on it. So first of all, there has to be a clear expression, and it has to be absolutely obvious from the language of the statute. And if it's necessary implication, it's still got to be absolutely clear. So the cases are, first of all, Morgan Grenfell, limited against special commissioners of income tax. That's authorities, tab 67, paragraph 8, memory stick, page 2897. I'll just read, if I may, from Lord Hoffman from the Appellate Committee. The courts will ordinarily construe general words in a statute, although literally capable of having some startling or unreasonable consequence, such as overriding fundamental human rights, as not having been intended to do so. An intention to override such rights must be expressly stated or appear by necessary implication. And then in the same case, Lord Hobhouse, see paragraph 44, referred with approval to Lord Hoffman's speech in Sims. Sims, for your note, is tab 68 of the authorities bundles, memory stick, page 2992. An important aspect of the principle brought out by Lord Hoffman, he said this: parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The constraints upon its exercise by Parliament are ultimately political, not legal. But the principle of legality means that Parliament must squarely confront what it's doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there's too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process, in the absence of express language or necessary implication to the contrary. The courts therefore presume that even the most general words were intended to be the subject to the basic rights of the individual. And then the final case on this, which I'll just give you for reference, is Pearson, Authority tab 69, memory stick page 2944. And so we say that the fact that there may be no statutory requirement to bring CANH PDOC cases before the court does not mean that there is no such requirement stemming from the common law and or from the European Convention. Or, importantly, that the hitherto prevailing practice of requiring such cases to be brought to court does not satisfy such requirements as a matter of substance. Materially, we say the mere fact that a requirement to bring all PDOC CANH cases before the court is described as a rule of practice and is not enshrined in a statute does not mean that it cannot, at one and the same time, satisfy common law and convention requirements, or that it's unnecessary for a mechanism of that kind to exist for such requirements to be satisfied. If, as we contend, the common law and convention are not silent as to the need for protective mechanisms in respect of vulnerable patients, then it matters not whether one calls this a rule of practice or something else. It is always in this area of the law, the substance that matters. And of course, I make this point, and I'll come back to it, that when you look at Bland, when you look at F, these are cases where clinicians brought cases to court. Now, there is this area of law which is very difficult, and I think possibly still not resolved, as to whether a doctor can come to court and get a declaration that immunizes that doctor from possible criminal liability in the future. Lord Mustill in Bland found that an extremely difficult area, as I think did Lord Brandon in Re-F. But so the real focus of
Well,
those...
you're not asking us to say that
No.
the decision was wrong.
No. I'm not getting into that.
Get an advance declaration.
I don't want to
what
get...
you propose to do will be lawful.
I don't want to get into that at all. It's very difficult terrain. But all I'm saying is...
It's been decided by the House of Lords.
Well, I'm not going to get into it, my lady. What the House of Lords was effectively looking at in those areas, however, this is the only point I want to make, was essentially the question of the clinician's liability. But at the same time, the courts made observations which quite clearly relate to the need to protect patients. But the only point I make is that the focus of those cases began as, am I acting lawfully if I do this? It's a different question that's raised in this case, which is what mechanisms are necessary to protect the patient. As it happens, we say, the mechanisms that were laid down in Bland and before Bland in a parallel context in Re-F are, as it happens, mechanisms which are necessary to protect patients unless they're supplanted by an one of equal substance. But I just want to make that point to put those cases in context, because I think Mr. Sachdeva says, as he put it below, these are just rules of practice, and don't worry about them, they're not compulsory. Well, one has to look at this as a matter of substance and not form. And what we say is, and we put this in our case at paragraph 77, but I did want to go to it. The respondents and the learned judge's analysis takes the impermissible second step across the chasm, Lloyd George's second step across the chasm, by supposing that the description of the need for a court application in PDOC cases as a mere rule of practice means that once dispensed with, the need for a mechanism to protect the patient disappears along with the practice, leaving the concerns expressed in Re-F and Bland unaddressed. We say that is an impossible position to take. The common law has always provided a role for the courts to scrutinise decisions concerning the withdrawal of CANH from those in PDOC, even if ultimately the extent of the court's involvement is relatively brief. And coming back to this point about do all cases have to go to court, just remind this court that of Mr. Justice Baker's proposals for future case management in his paper, A Matter of Life and Death. Which
so what were his proposals?
Protocols, effectively in case management. But I can take you to it, my lord. What? It's tab 57 of the authorities. That's the one reference I haven't got.
Perhaps you'd like us to read it to ourselves.
Yes, but I can take you to it and then let the court read it. So it's Authorities Bundle 6, tab 57, and, oh yes, this was his Shrivel lecture, and it starts at memory stick page 2332 and goes through, in fact, to 2339, and perhaps I can just highlight two passages in that and let perhaps the court read it in more detail.
Certainly.
But if you go to 2334, what you will find a third of the way down the page, third and most important from the court's perspective, the clinical diagnosis of the level of consciousness is exceedingly difficult. And then perhaps just below that, 2 paragraphs below it, much has been written about these protocols. The principal potential weaknesses are no definitive criteria of awareness, so that such assessments depend on judgment and interpretation, which may be challenging even for the professionals expressed in carrying out the assessments. And a little below that, the last sentence, the assessment tools are very important, and the courts invariably require such assessments to be carried out before any applications made to the court. But it's important to recognize that they are not by themselves determinative of the outcome in any case. And then if you go to page 2339, right towards the end of the article or lecture, really it's from the second sentence of the paragraph beginning, I have considerable sympathy for these arguments. I suspect he's referring there to Mr. Sachdeva's type of argument. I acknowledge that in many cases hitherto, proceedings have been unnecessarily drawn out and delayed, and with others I'm in the process of attempting to streamline and simplify the court process. In particular, the adoption of a pre-proceedings protocol which spelt out the obligations on the parties to ensure that all necessary steps were undertaken before the start of the case, including independent testing of the level of consciousness, could lead to a significant reduction in delays. When all parties are agreed as to the outcome and all the necessary evidence available, there is no reason why the court's decision should not be made in weeks rather than months, as happened hitherto. And then, just in that last paragraph in that column, about halfway down, but as I have, I hope, demonstrated above, both medical science and the law are still evolving. So,
I'm sure it was my fault. I rather understood that your reference to his protocols were protocols which would obviate application to the court,
yes,
rather than pre-proceedings protocols.
I think that your Lordship was right to see the ambiguity in the way I put it. I think it is Mr. Justice Baker's view in that article that ultimately the court should always be involved. What I am saying is that may or may not be right. It's not necessary for me to make that submission today, because what is important is that unless and until effective protection is devised, whether that be Mr. Justice Baker's evaluation or an evaluation of the need for third-party scrutiny with some kind of filtering system, the present system should continue. Thank you. Where I put it. So we say that the entry into force of the MCA, and in particular the defence afforded by Section 5 of the Act, does not in any way dilute the court's exclusive function of determining patients' rights, subject to the point that there might be a way of protection which came close to that, if in fact there wasn't any doubt in a particular case identified by a neutral third party. Of course, the judgment in Bland was made against a set of facts which could not have been starker. The facts there were that I think by the time of the appeal, Mr. Bland had been suffering in PVS for more than 3.5 years, and yet the law lords considered even in that type of case, there was a need for a court application. Now, what I would say here is that the second respondent has in this particular case been able to participate in a way that's unusual, or maybe relatively unusual. She was able to instruct solicitors, obtain her own expert opinion, etc. But that won't be the case for a great many people, a great many of the family. And what is agreement, again, to a diagnosis? I'll come back to that shortly. But the real point I want to make here in Proposition 5 is that the argument that because there is a statute, there cannot be common law or convention protection, certainly cannot be common law protection, is flawed. When we get to the convention, we don't have to read the MCA as being incompatible. You read the MCA as being entirely compatible, but nonetheless, the essence of the convention right has to be respected. May I move now to Proposition 6, and this will take me both into Bland, but also into the convention rights for which, and common law rights for which we, as I say, contend. Now here we say that in order to, and this will take me also eventually into Proposition 7, in order to deal with the next questions that follow, if you like, the guts of the central issue, it's important to consider 5 questions. Question 1, was there at the time of Bland a rationale requiring mandatory applications to the court in such cases? Question 2, was that rationale one that required the need for common law and or fundamental rights protections? Question 3, did that rationale disappear with the enactment of the Mental Capacity Act? Question 4, did that rationale disappear because of advances in medical science? Question 5, are such cases, by which I mean CA and HP DOC cases, deserving of special protection? I'll come, if I may, to questions 4 and 5 when addressing the combination of special features of these cases in Proposition 7. Can I therefore start with the rationale in Bland? And very clearly articulated, and I can take this relatively quickly because we identified the various speeches in Bland in our case. First of all, see paragraph 31 of our case, Lord Keith, at page 859E to G, memory stick page 720. And it's perhaps necessary to go through these, because I want to draw the threads together when I've gone through them. The decision whether or not the continued treatment and care of a PVS patient confers any benefit on him is essentially one for the practitioners in charge of his case. The question is whether any decision that it does not, and that the treatment and care should therefore be discontinued, should as a matter of routine be brought before the family division for endorsement, or the reverse. The view taken by the President of the Family Division and the Court of Appeal was that it should, at least for the time being, and until a body of experience and practice has been built up which might obviate the need for application in every case. As Sir Thomas Bingham, Master of the Rolls, said, this would be in the interest of the protection of patients, the protection of doctors, the reassurance of the patients' families, and the reassurance of the public. I respectfully agree that these considerations render desirable the practice of application. Then, at paragraph 33 of our case, Lord Lowry, page 875 F to H, memory stick page 736. Procedurally, I can see no present alternative to an application to the court, such as that made in the present case. This view is reinforced for me when I reflect against the background of your Lordship's conclusions of law that in the absence of an application, the doctor who proposes the cessation of life-supporting care and treatment on the ground that their continuance would not be in the patient's best interests will have reached that conclusion himself and will be judge in his own cause unless and until his chosen course of action is challenged in criminal or civil proceedings. A practical alternative may, however, be evolved through the practice of the Family Division and with the help of the Medical Ethics Committee, which has already devoted so much thought to the problem and possibly of Parliament through legislation. It will, of course, be understood the court has no power to render lawful something which without the court's sanction would have been unlawful. When I take into account the case now before your Lordships could not be clearer on its facts, I have to say that I'm left with the feeling the general proposition is not satisfactory. I should say, I don't think anyone went as far as Lord Lowry in the context of liability. Paragraph 34 of our case, Lord Brown-Wilkinson, page 885 E to F, memory stick page 746. I'm very conscious that I've reached my conclusions on narrow legalistic grounds which provide no satisfactory basis for the decision of cases which will arise in the future when the facts are not identical. I must again emphasize that this is an extreme case where it can be overwhelmingly proved that the patient is and will remain insensate. He neither feels pain from treatment nor will feel pain in dying and has no prospect of any medical care improving his condition. Unless, as I very much hope, Parliament reviews the law, the courts will be faced with cases where the chances of improvement are slight or where the patient has very slight sensate awareness. I express no view on what should be the answer in such circumstances. My decision does not cover such a case. I therefore consider that for the foreseeable future, doctors would be well advised in each case to apply to the court for a declaration as to the legality of any proposed discontinuance of life support where there's been no valid consent by or on behalf of the patient to such discontinuance. And finally, Lord Gough, 874B to E, memory stick page 735. For the respondents, Mr. Francis suggested that an adequate safeguard would be provided if reference to the court was required in certain specific cases, i.e. one, where there was known to be a medical disagreement as to the diagnosis or prognosis, and two, problems had arisen with the parent patient's relatives, disagreement by next of kin, with the medical recommendation, actual or apparent conflict of interest between the next of kin and patient, dispute between members of the patient's family or absence of any next of kin to give their consent. There is, I consider, much to be said for the view that an application to the court will not be needed in every case, but only in particular circumstances, such as those suggested by Mr. Francis. In this connection, I was impressed not only by the care being taken by the Medical Ethics Committee to provide guidance to the profession, but also by information given to the Appellate Committee about the substantial number of PVS patients in the country and the very considerable cost of obtaining guidance from the court in cases such as the present. However, in my opinion, this is a matter which would be better kept under review by the President of the Family Division than resolved by your Lordship's House. I understand that a similar review is being undertaken in cases concerned with sterilisation of adult women of unsound mind, with a consequent relaxation of the practice relating to applications to the court in such cases. For my part, I would therefore leave the matter as proposed by the Master of the Rolls, but I wish to express the hope the President of the Family Division, who will no doubt be kept well informed about developments in this field, will soon feel able to relax the present requirements so as to limit applications for declarations to those cases in which there's a special need for the procedure to be invoked. I will come back to the sterilisation point, but as I understand it, notwithstanding Lord Gough's hope that there would be a review, as recently as 2013, in a case, which I'll mention, Mr. Justice Cobb, I think, said that all cases should still be brought to court. So I'm not sure that review happened. It may be that this court has greater knowledge than I do. But even in that context, that review has not yet happened. So we draw from these passages that at least three of their lordships, Lords Keith, Lowry, and Brown-Wilkinson, took the view that the interests of the protection of patients, not just doctors, and the reassurance of the public rendered it desirable that until a body of experience and practice has been built up, applications should be made to the Family Division in any case where it's considered by the medical practitioners in charge that continued treatment and care no longer confer any benefit. Lord Brown-Wilkinson, in the passage that I have just cited, appeared to foreshadow the specific dilemmas that the, at the time unrecognised, diagnostic category of MCS would bring, when he noted that cases to come would be less clear-cut than the extreme PVS case of Anthony Bland, and may well include those with some sensate awareness or some prospects of improvement, either category of which would include those now diagnosed as in MCS. Further, although the opinions in Bland are couched in terms of being as a matter of practice, the consensus was that such cases should be brought to court out of concern for the need to protect patients, with Lord Gough as the fourth agreeing that the practice of referral to the court should continue. Even the fifth Law Lord, whose speech I haven't mentioned, Lord Mustill, who did not address the question directly, was astute to the danger of Bland creating, quote, false conclusions in situations where the situations are similar but more finely balanced. See page 886D, memory stick page 747. Finally, it is, we say, implicit from these passages that whilst a dispute should always prompt an application to the court, the absence of a dispute does not render it unnecessary to approach the court. It's not the existence of disagreement that gives rise to a need for judicial scrutiny, but that the decision being made is the critically serious determination whether or not to continue to provide life-sustaining treatment to a patient with at least potentially a viable, albeit profoundly disabled life.
So this is subject to the caveat that a proper practice might develop so that this was unnecessary.
Yes.
And in the present case, I mean, you say that the judges decided a point at the highest level of legal abstraction, but I'm not sure that that's right. The judge was given considerable evidence, which she recited in her judgment, about the clinical care, the advice received, including from independent consultants. And when she came to her conclusion, she said that there's already authority in REM that where clinicians have followed the Act and good medical practice, and there's no dispute, and no other doubts or concerns have been identified, there's no requirement to bring the matter before the court. And then she says, applying that, this is an appropriate case. So her judgment doesn't actually seem to me to be as abstract as you suggest. It's a specific judgment in this specific case where there are no doubts. She's not saying that in a case where there are doubts you could have a different, you could avoid going to court. And she's not saying that in a case where good medical practice hasn't been followed, you don't need to do more. What she's saying is on the specific facts of this case, this is an appropriate case, and there is no invariable rule. Now, Bland wasn't saying there was an invariable rule. It said that it might, with time, be subject to good medical practice.
Can I deal with both of those points?
Yeah.
At the very end of your articulation, your Lordship moved from this case to Bland, so I'll deal with each of them. As far as Bland is concerned, we don't say that the court in Bland was saying, as a matter of common law protection, this must happen. What we say is that the court was there concerned with civil criminal liability, effectively, and was saying it's highly advisable for doctors to come to court. What we actually say, however, is that the protection that was devised in Bland and earlier in F met the robust common law and convention standards of protection that are required. They met them. And as far as this case is concerned, I don't want to really waste time by repeating my submissions. I didn't use the words high level of abstraction, but what I did say was the judge absolutely, see paragraph 21, Roman 3, considered that she was determining a pure point of law, and she refused permission for us to investigate the matter. Now, if...
Well, that's against a background of the facts which she recited about all the medical
the learned judge
statements.
wasn't saying, as I understand it, there could be no doubt about this case if the official solicitor investigated. If she said that, well, at least we might, I would then have said, well, how do you know? When we come to Dr. Badwan, of course, has a report which shows that he did think that further investigation was needed. The question really that I think your Lordship is hitting on, as far as our argument is concerned, is when can you say there isn't doubt? And I think that what I would certainly say about this learned judge's judgment is she wasn't doing a best interest evaluation, she wasn't purporting to apply the facts of the case, she was being asked to give a generic declaration, and that's what she did, shorn of the civil criminal liability part of it. But she illogically purported to restrict it to the facts of Mr. H.Y.'s case. I made no submissions about the facts of the case. I made it absolutely clear to the judge we had had very little notice of the hearing. We were not in a position to make submissions on the facts. What I wanted to say was that what emerges from the speeches that I've referred to in Bland is that we are dealing with the most serious of decisions. And there is an echo of that, the importance attached to that, in the case that this court decided, seems a long time ago, I think it was last year, early last year, ACCG. And that's in the bundles, Authorities Bundle 2, tab 15, memory stick page 974. And this is Your Ladyship, at paragraph 38. Perhaps I can just read that briefly.
Sorry, could you give me the page reference again?
Yes, of course. It's memory stick page 974.
Thank you.
So, at paragraph 38, Your Ladyship said this: Section 5 of the 2005 Act gives a general authority to act in relation to the care or treatment of P to those caring for him who reasonably believe both that P lacks capacity in relation to the matter and that it will be in P's interest for the act to be done. This will usually suffice, and then these important words in our submission, unless the decision is so serious that the court itself has said it must be taken to court. But if there is a dispute, or if what is to be done amounts to a deprivation of liberty for which there is no other authorization under the deprivation of liberty safeguards in Schedule A1, then it may be necessary to bring the case to court, as the authorities did in this case. The court clearly has jurisdiction to make any of the orders or declarations provided for in the Act. The question is not strictly one of jurisdiction, but of how the case should be handled in the light of the limited powers of the court. What we say that passage reveals, at least implicitly, in a judgment with which Lord Wilson, Lord Reid, Lord Carnwath and Lord Hughes all agreed, what that judgment recognises is that it's the seriousness of the decision, not the existence of a dispute about that serious decision, that mandates the application to the court. Now, without a requirement to bring the matter before the court or equivalent process that guarantees the right, the incapacitated individual has no protection against the risk that those in charge of his or her care may too readily withdraw CANH on the asserted grounds that the patient's life, if prolonged, would not be worth living. And this is particularly so where the patient has no relatives, is unbefriended, so there's nobody to review the clinical team's position, nor does the patient have protection from over-reliance on past informal statements, casually made when the patient had capacity, but without any real contemplation of the present circumstances, leading to the conclusion that their current wishes and feelings would dictate that they no longer wish to receive CANH. In other words, it's the distortion that can occur in trying to look at the assumed patient's view. Such circumstances risk the patient's continued existence being subject to value judgments in respect of the lives of the profoundly disabled. So we say, I mean, this is just the first of 5 questions, but we say the rationale in Bland, there was clearly a rationale in Bland, and that rationale was, when you really examine the speeches, directed to and focused on protecting the patient. That's why I say it matches the requirements of the common law and of the Convention. Of course, the Convention was a gleam in those days, really, in the court's eyes. It hadn't come to pass in terms of domestic law. So, second question, does this rationale in Bland require common law and/or fundamental rights protection? And in our respectful submission, there is the clearest and closest of links between the rationale for court scrutiny of CANH PDOC cases expressed in Bland and the need for common law and fundamental rights protections. Where does it come from, that link? Well, we say the common law is clear that the principle of the sanctity of life should be paramount. It's, of course, not an absolute presumption, but it is a strong presumption. The practice of bringing cases of withdrawal of CANH from PDOC patients before the court upholds that principle by providing an essential safeguard to that category of patients from the risk of their doctors and families, no doubt in good faith, being wrong about their diagnosis and their best interests, and in particular, misunderstanding P's previous wishes, the points I've just made, and feelings, and the beliefs and values likely to influence P regarding continuing a disabled life if she or he had capacity. The recently prevailing practice, supported by the practice direction, guarded against the possibility that family members might have ulterior motives, conscious or not, wrongful or not, shaping the information they then provide to doctors regarding P's own past wishes and feelings. As uncontroversially pointed out in the Court of Appeal in Bland, see Memory Stick page 669, Authorities Bundle 2, tab 9, quote, and this is from Sir Thomas Bingham, profound respect for the sanctity of life is embedded in our law and our moral philosophy as it is in that of most civilized societies in the East and West. Can I also, just in terms of going back to the relatives' position, echo Lady Justice Butler Sloss in Bland at memory stick page 678, where she stated as follows: "The views of the family must always be treated with respect and be an important consideration in the overall assessment. In some cases, the evidence of relatives will be required to be treated with great caution, since there may be hidden motives." So we said the link between the respect for life and the protection of the common law is well established. And it's that respect that required protection in Bland. It's that respect which at root informs the common law rights for which we contend and the convention rights for which we contend. At paragraph 10 of our case, we give an example in the context of immigration, which is the Bugdakai case, the anxious scrutiny case. I can just give a reference. It's paragraph 10 of our case, memory stick page 1171. I'm not going to develop that comparison now. And the relationship, and this is where one really sees the clearest articulation of the protection afforded by the common law and the need for the common law to express that protection, is in a case before Bland, the case of In Re F, the sterilisation case. That is Authorities Bundle 2, tab 13, and I was going to go straight to Lord Brandon's speech, which is memory stick page 909, page 55, letters D to F, and I can read it. Lord Brandon said this: "There are, however, cases where adult patients cannot give or refuse their consent to an operation or other treatment. One case is where, as a result of an accident or otherwise, an adult patient is unconscious and an operation or other treatment cannot be safely delayed until he or she recovers consciousness. Another case is where a patient, though adult, cannot, by reason of mental disability, understand the nature or purpose of an operation or other treatment. The common law," and this is the point, "the common law would be seriously defective if it failed to provide a solution to the problem created by such inability to consent. In my opinion, however, the common law does not so fail. In my opinion, the solution to the problem which the common law provides is that a doctor can lawfully operate on or give other treatment to adult patients who are incapable, for one reason or another, of consenting to his doing so, provided that the operation or other treatment concerned is in the best interest of such patients. The operation or other treatment will be in their best interest if, but only if it's carried out in order to save their lives or to ensure improvement or prevent deterioration to their physical or mental health." What I derive from that passage is the importance of the common law articulating protection. He concluded, see memory stick page 9110, page 56, E to F, he concluded that the lawfulness of the treatment turned not on the sanction of the court, but on the fact that it was in the patient's best interest. But he outlined why the court's approval of proposed treatment was highly advisable. He said this: "Although involvement of the court is not strictly necessary as a matter of law, it is nevertheless highly desirable as a matter of good practice. It is necessary to have regard to the special features of such an operation. These features are, first, the operation will in most cases be irreversible. Secondly, by reason of the general irreversibility of the operation, the almost certain result will be to deprive the woman concerned of what is widely, and as I think rightly regarded as one of the fundamental rights of a woman, namely the right to bear children. Thirdly, the deprivation of that right gives rise to moral and emotional considerations to which many people attach great importance. Fourthly, if the question whether the operation is in the best interest of the woman..."
To what extent would those be justiciable?
Which bit, my lady?
Well, he's giving 4 reasons for saying why it's a good idea to take these cases, sterilisation cases, to court.
Yes.
Generally irreversible.
I think there are 6,
Deprivation of a
actually.
fundamental. Well,
Yeah.
I haven't written them all down yet because I've interrupted you halfway through. But what was concerning me was, yes, it does raise moral and emotional considerations. Of course it does. But to what extent could those be resolved by a court?
No. Well, my answer to that is that a lot of these questions, I'll finish reading them in a second to get to 6, but a lot of these questions are actually risk questions and legal questions. If your ladyship asks me about morality, I go back to the comments of Lord Hoffman and I can't remember where else, but I read them earlier in Bland. Morality in this part of the law is actually quite important. The law should, although it's not strictly a legal consideration, the law and morality should not be far apart. So that's where I would put that. It's not so much justiciability as it's a kind of litmus paper double check of whether the law is on the right tracks. I think I got to 4.
You had.
Fourthly, if the question whether the operation is in the best interest of the woman is left to be decided without the involvement of the court, there may be a greater risk of it being decided wrongly, or at least of it being thought to have been decided wrongly. Fifthly, if there is no involvement of the court, there is a risk of the operation being carried out for improper reasons or with improper motives. And sixthly, involvement of the court in the decision to operate, if that's a decision reached, should serve to protect the doctor or doctors who perform the operation and any others who may be concerned in it from subsequent adverse criticisms or claims. And then in the same case, Lord Gough, see memory stick page 933, I'll just read the part from that, which is in our case at paragraph 29, that guidance, we interpose from a court, should be sought in order to obtain an independent, objective and authoritative view on the lawfulness of the procedure in the particular circumstances of the relevant case after a hearing at which it can be ensured that there is independent representation on behalf of the person upon whom it's proposed to perform the operation. Now, if that is an important feature in sterilization cases, it must be an important factor in a case where it's not just the irreversibility of an operation that is at stake, but the existence of a life. So what we say is that the passages in Re-F demonstrate that there is the closest of connections between a so-called rule of practice and the protection afforded and required to be afforded by the common law. Indeed, we would say the necessary implication to be drawn from these passages is that for the 6 reasons set out by Lord Brandon in his speech, only the court can be the arbiter of what is in a patient's best interests. It is to be noted, though, also that 5 of the reasons engage protection of the patient. Now,
So does that mean that he was wrong when he said at first that there was no necessity, strict necessity as a matter of law?
No, what he was dealing with, I come back to this, that the primary focus of that case and Land was on the civil or criminal liability of the clinicians. What I'm suggesting is that as the law has developed in terms of the European Convention, and indeed having regard to the factor mentioned by Lord Gough, there are highly relevant convention and common law rights. And if you go back to what Lord Brandon said in Re-F, that the common law cannot be powerless, it must fashion, if necessary, a remedy. What we say is that all the essence of the protections that were being articulated in these cases, as the law has later developed, show that the common law has always regarded this kind of protection as important. And I say the common law, the convention as well.
Sure.
My Lord, let me put it another way. There are only 2 possible analyses of this. Either we're simply talking about rules of practice which don't really have to be followed, or we're talking about something more serious. If we're talking about rules of practice that don't have to be followed, what it means is that the law has really been, for the last 20-odd years, in a state where the clinicians could just have ignored the rule of practice. It doesn't really matter. What we say is that if you actually look at it in context and you look at the nature of common law protection, I haven't got to that yet. When you look at the nature of the common law and convention protections involved here, you've got to have something more than just guidance. And what you have currently was, perhaps still is, depending on this court's decision, a practice that effectively protected such patients. If you abandon that practice with nothing else in its place, we say the common law is defective and we say that it's not matching convention.
Well, that's the rub, isn't it? I mean, nothing else in its place. The whole question seems to me, nobody is suggesting you can abandon good practice in relation to either the Re-F type situation or the present. The question is, whether good practice actually requires you in every case to go to court, and if not, in what cases can you dispose of it?
The question is, in my respectful submission, who resolves doubt? Who identifies doubt? Who resolves doubt? That's the question. And that's the key question, because no mechanism which fails to address that question is adequate if we're right about the content of the common law and conventional rights.
So you're saying that there has to be doubt before an application to the court is required by the common law, but it's only the court that can declare that there is no doubt.
Well, that's one way of putting it, but another way of putting it is you can't assume there is no doubt without third-party scrutiny, because otherwise you've got all the reasons mentioned by Lord Brandon in F, and doctors being judges in their own cause, the protection of doctors, all the rest of it. You need something which reassures the public, again going back to Lord Brandon. You need something which legitimizes what is happening in a very visceral class of case, where the withdrawal of what many see as basic care is taken away. You need something, and it can't be just decided in our submission, if we're right on the legal analysis, on the fiat of the doctors, however well-intentioned.
And only in this area you'll come to why this area is so special, and only if it's a matter of life or death.
I have to come to that, yes, yes. But where I pull back is in trying to make any submissions about the precise mechanisms that there should be. What I do say is, in the absence of an identified mechanism, we must keep what we've got for the moment. And it may be a very long moment, as the sterilisation review, or non-review, as I apprehend, demonstrates. But it may be that it's capable of being resolved. But it will always be this question about the doubt. So can I now turn to the various rights in play? And we say the following rights are engaged, though I will not be dealing separately with Article 8. The appellant's Articles 2, 6, 8, and 14 taken with 2, in conjunction with 2 rights, are engaged, as well as the patient's constitutional rights of access to a court. So, the first point to make, dealing with Article 6. Article 6 is perhaps the starting point, because it's important both in its own right, see Lord Gough in, I think it was Lord Gough in F, but it's also a means of informing the content of Article 2. So if I may address that first, but what I would say is the respondent accepts that Mr. Y's Article 2 and Article 8 rights were engaged, but he says Article 6 and Article 14 taken with Article 2 and common law rights of access are not engaged. None of those rights are engaged on the respondent's analysis. So first of all, may I remind this court of the learned judge's analysis of the Article 6 issue. It appears at paragraph 47, see Appendix Tab 2, Memory Stick, page 157. This is Justice O'Farrell held that Mr. Y's Article 6 rights would only be engaged, and I quote from paragraph 47, in the event of any dispute or doubt as to the medical evidence and or his best interests. Now that objection, relevant also to access to the court, appears curiously to be founded on nothing more than that which the learned judge almost immediately cites from the Strasbourg case of Ashingdane, which we see at paragraph 55 of Ashingdane, Memory Stick, page 2077, namely that rights of access to a court, quote, may be relied on by anyone who considers on arguable grounds that an interference with the exercise of his civil rights is unlawful. Now that's the bit in Ashingdane that the learned judge relied on. The obvious difficulty we respectfully submit with the judge's reasoning is that he ignores the fact that the very passage she cites from Ashingdane erodes the validity of her reasoning. Whether or not there is an arguable dispute or doubt is, on the logic of Ashingdane, one that can only fall to the affected person, or presumably to his neutral representative, to consider. He's got to be able to consider that there is a doubt. That's so for the very reason that otherwise, to take this case, the clinicians will be, to quote Lord Lowry from In Ref, judges in their own cause. Now, if the person on the other side of a dispute can simply say, there is no arguable dispute, and by necessary inference, therefore, the person affected cannot be heard to say otherwise, it makes nonsense of any right of access to a court. We wouldn't say necessarily that a right of access to a court was eroded if a third party thought an access to the court wasn't needed, but this is not what is being suggested. The learned judge is saying Ashingdane is authority for the proposition that where there's no doubt, there's no right. And yet the very passage she cites to make that point vitiates her logic. So the learned judge's reasoning, we say with great respect, can only end in circularity, because the way she defends it is by reference to an erroneously assumed best interest litigant, namely the official solicitor. And that's why she goes on in paragraph 47 inferentially to assume that the official solicitor is appearing on a best interest assessment. But as I've explained, he clearly was not. As I have said, the case was advanced as one raising a pure point of law. It was for that reason that the official solicitor was denied the adjournment he reasonably sought, and he was therefore denied the opportunity of identifying an arguable dispute or doubt before the court. And so the Ashingdane right of considering whether there is an arguable case, a doubt, is removed. And as we put it in our case, without hearing evidence, it was impossible for the judge to ascertain if in fact there was a dispute about the medical evidence or his best interests. In approaching the matter in this manner, she overlooked the fact that Mr. Y's Article 6 rights and 2 rights were engaged by virtue of the first respondent, a public body's decision to withdraw CANH, and the court's obligations pursuant to Section 6 of the Human Rights Act. The only way in which the court could ensure that his convention rights were protected was for the official solicitor or other litigation friend to be permitted, amongst other things, to instruct his own expert so as to be able to make informed submissions if considered appropriate.
But if this submission is right, then it certainly isn't limited to situations of PVS, is it? It must cover every conceivable situation where doctors decide it's in the best interests of a patient who lacks any sort of capacity.
No, I don't
to have an operation. Well, it must do, because in any of those situations, there's a risk that the treatment might constitute a battery. And on your argument, the patient is entitled to access to a court to test that. He can't directly make up his or her mind, and so some third party, like the official solicitor, must act for them.
Well, I wonder if I could attempt to say why that is not our submission. It's not our submission because, as the learned judge I think we say in paragraph 86 of our case, the right of access to the courts is not absolute. It isn't absolute. It will depend upon the seriousness of the decision. It will depend upon the particular category of case. And where you have, just to take an example of the dying process, a patient is clearly dying. The clinicians have to manage those symptoms. We don't contend that those cases fall into the same category as this case. What we do say is that when you are dealing with a case like this, and for the reasons I have to come to in Proposition 7, I can't succeed in this case if I don't win on Proposition 7. But when you are dealing with this special category of case, it is not, it is of the utmost importance that the patient has a right, a voice. And That is what Ashingdane says. Now, the reason why it's so important is because of the seriousness of the decision, having regard to the type of case that this is. Because a life that might have lasted years is taken away without any voice for the patient through the official solicitor. It may be there'll be no cry. It may be it will be the right decision, but it may not be.
Are you asking, therefore, us to go further than the Court of Human Rights in the case which I expect everybody calls Lambert, but may not be properly pronounced that way?
I pronounce it Lambert. No, we're not. I'll analyse Lambert, but our position on Lambert is that it's not a great deal of help to look at comparative French procedure where that procedure shows there were guarantees. There are no guarantees.
It didn't involve a court, did it?
No.
No.
But, of course, that wasn't...
So I'm just thinking about it in terms of your Article 6 argument.
Yes. You're right, my lady, to, if I may respectfully say so, to test the proposition. But when we look at those Strasbourg cases, we will see that not one of them involved a relevant Article 6 argument. It wasn't put. So all those cases were decided by reference to an established procedure with guarantees. I think I have actually said at an earlier stage in this case that I would be very wary about making submissions to this court as to the exact process that should be followed. But one can see, for example, that if you had a process whereby instead of being refused an adjournment on the particular way this developed, the official solicitor had had the opportunity and had said, actually, I don't have any need for further investigation, the proceedings could have closed quite quickly. You could imagine an alternative procedure where you never get to a court, but where there are procedures laid down for resolving, for giving the patient a voice. I wouldn't say in that situation that the right of access to the court had necessarily been taken away or deprived. What I do say is, in this case, the learned judge analysed Ashingdane back to front, and she got it wrong. And it's important because no Strasbourg decision has yet confronted Article 6 in this particular area of the law, and our respectful submission is that when you do, the principles are clear, provided, I absolutely accept this, provided that we succeed on the last proposition. I have to show that these cases are sufficiently important to justify a voice before the court, or at least the possibility of a voice.
It's not so much sufficiently important, because of course they're important.
Yes.
It's sufficiently different
Yes.
from other equally important questions.
Yes, your ladyship is absolutely right, and that's what I mean. That's what I should have said. So, in this case, in their case, I should say, the respondents essentially repeat, see paragraphs 123 to 127 of their case, memory stick pages 135 to 136. They essentially repeat the reasoning of the learned judge and maintain that there must be a dispute before there's a right of access to the court. Although they're right, see paragraph 125, to suggest that the existence of a dispute cannot be assumed, the essence of the Article 6 right, as I have already cited from Ashingdane, is to ensure that the person affected is given the opportunity to consider whether there's a dispute. In a case such as the present, that could only ever have taken place if the official solicitor had been given the opportunity for such consideration. So that is effectively Article 6. Oh, yes, sorry. The learned judge's conclusion, see paragraph 49, that Parliament did not consider it necessary to insert into the MCA a requirement that there should be oversight by the official solicitor and or the court in all cases of withdrawal of CANH, again, we say with respect, is not material to the analysis because of Proposition 5. May I now turn to Article 2? And as I've said, I'm not raising a separate issue on Article 8. I'm not sure whether the judge addressed this in detail, but what the respondent relies upon, in part, is Lambert. And Lambert is at Authorities 2, tab 17. essentially, and I have to deal with this relatively quickly, because I've only got another hour, I think, after lunch. But that was a case where the French so-called collective procedure, which doesn't require a court application, didn't infringe Article 2. No consideration of whether it might infringe Article 6, because it simply wasn't raised. We say that Lambert does not give any principled answer to our case. First of all, as I said, Article 6 was not argued or therefore considered by the court. However, I would invite the court to look at paragraph 143 very quickly, memory stick page 1033, because this is where it's all going to come back to. The court held that there must be a judicial remedy in any case of doubt. The court was not asked to consider the withdrawal of a procedure designed to enable a neutral third party to raise a doubt that was not raised by the treating clinicians. Moreover, it was not suggested in Lambert that Article 2 requires per se that withdrawal of CANH could only follow a judicial determination. What the court did was undertake a detailed examination, that was its focus, of the French procedure, holding that on the facts of that case, the particular procedure did satisfy Article 2. Well, I've already said that I can envisage cases where a suitably devised procedure, which may not necessarily always lead to a court hearing, could satisfy Article 2. But what we say is clear from Lambert is that one of the conditions, by reference to the procedure in Lambert, was that there was a formally prescribed procedure with guarantees. So that's our first point on Lambert. Second point, any analysis of Lambert we say is unhelpful because it can only involve a comparative exercise as opposed to one from first principles. And the point is, really the point I've just made, that in Lambert, the mandatory procedure, not merely professional guidance. Professional guidance is always followed, as we see, actually, I think, from Replacement Authority tab 78, which is Mr. Sachdev's authority. We know that guidance isn't always followed. So we say that Lambert is not a help in determining this case. We say that similar points arise in relation to the recent decision of AFRI, which is in the supplementary bundle, supplementary memory stick pages 4 to 16. Can I again take that case quite quickly? It's a very recent case. I think it's February of this year, or January of this year. That was a case where there was a court challenge brought by dissatisfied parents, it was before the court, and where the court challenge failed on its merits by reference to a domestic court procedure called the collegiate college procedure. So, France, you've got the collective procedure, and in the AFRI case, you've got this collegiate college procedure. Article 6, oddly enough, in AFRI was raised, but it wasn't by reference to the need for judicial adjudication. It was claimed by parents seeking a coextensive right of decision-making. But the important point, and the short point to make about AFRI, is, see paragraph 28, that it applied paragraph 143 of Lambert. So the court was alive to the fact that any case that might raise a doubt should be the subject of a judicial remedy. That's what it decides. So that brings me finally, and relatedly, to what we say is one of the key questions in this case, the question of doubt. Now, Mr. Sachdeva relies, understandably, on the obiter comment in the Court of Appeal in Burke. Burke is to be found at Authorities 2, tab 11. I'm not going to go to it.
Sorry, could you just remind me what the paragraph number was that referred to paragraph 143 of...
Yes, in AFRI it was paragraph 28,
Thank you.
my lady. Now, Burke was the case where the Court of Appeal said there was no legal requirement to make an application to the court where there's no dispute. I should remind the court, remind myself, because I was in it, that it was a patient who wanted a guarantee that he could have clinically assisted nutrition and hydration, should he want it, by means of an advanced decision. And the answer given was that you can't have a guarantee of treatment because doctors are not required to provide treatment. But as I say, that was a very different type of case to this. It was obiter. Secondly, we would suggest that the obiter comments in Burke have been overtaken, to say the least, by the ACCG case, where we are looking very much at the context of cases being brought to a court. Thirdly, and perhaps this is the key, the jurisprudence of the European Convention on Human Rights is consistent and makes clear that in cases of doubt there must be a judicial remedy. The real question, we're not going to get it from endless citation of authority. The real question here is, what does doubt mean in a case such as the present? That's the essence of this case. And this has not been the subject of a decision in Strasbourg. It has not been addressed in any of the cases, because it hasn't needed to be. It certainly didn't need to be addressed in Burke, given the nature of the issue. Simply referring to doubt does not address or answer the question as to who is to be the arbiter where there might be room for doubt, when potential parties who might bring the matter to court are not heard.
Are you saying, Mr. Gordon, that there will always be doubt in a case like this unless there has been an independent investigation?
I'm saying that there are cases, this was certainly one of them, by the way, in which further investigation might show room for doubt. If there is no room for doubt, a third party looks at this and says, look, this is obvious. And that may well be so where a patient, for example, is on the point of death through physical symptoms. Then there won't be doubt. I'm not saying you necessarily have to go to a court, necessarily, to isolate whether there is doubt. What I am saying, however, is that you've got to have a process which enables all cases to be looked at by a neutral third party in this special kind of case.
So I think the answer to my question is probably yes.
Yes.
Yes, there will always be doubt in these cases unless there has been a degree of independent investigation.
There will always be a potential.
Do you agree with that?
There will always be the potential for doubt, yes, which on further investigation might, rather like arguability in judicial review, arguable case which might turn out on further investigation, case which might on further investigation turn out to be arguable.
Well, surely, logically, the doubt exists until you've gone further and got the third party involved. I think the answer probably is yes to
Possibly,
Lord's
yes.
question.
I may be being syntactically too cautious in agreeing with that.
But the doubt may then vanish.
The doubt
as
may
the
vanish.
third person has had a look at it.
Exactly.
Yeah.
So, but that's really what is important in this case. I mean, there are one or two really important points. One is this, and the other is, of course, is PVS a special type of case? Now, we say it could not satisfy Article 2 if it was only subjective doubt in the minds of relatives and doctors that mandated a court application. To do so would impermissibly water down the presumption of the sanctity of life. It must be the potential for objective doubt that requires adjudication or consideration. And as I will refer to later, the present state of medical knowledge and the frequent failure of clinicians to apply rigorous diagnostic approaches or follow professional guidelines means errors can be made. We say that in the present state of medical knowledge and procedures, as far as we are aware, there is considerable doubt. We say that it is clearly premature to encourage the decision-making on CANH withdrawal away from the court's oversight. The importance, increasing importance, of the decision-makers taking into account the assumed viewpoint of a patient under the MCA enhances rather than diminishes the need for protection of Article 2 rights by a prescribed procedure that tests the evidence given by others that is the foundation for determining the patient's viewpoint. In the absence of an independent arbitrator wedded to an outcome, there is always room, perhaps this is the answer to your Lordship's question, there is always room for doubt about diagnosis, prognosis, and best interests, even where all persons consulted agree with the proposed withdrawal. That is the answer. Can I move lastly to Article 14, taken in conjunction with Article 2? This is addressed by the respondent in his case at paragraphs 128 to 130. We address it in our case at paras 94 to 96. Very simply, it's a very short issue. What we suggest here is, and one only has to live through the assisted dying cases to see it, Mr. Sach-Davis suggests that because there is a prohibition against assisted dying in the law, we're in a completely different position. That is to say, a patient lacking capacity who has potential PDOC is in a completely different position. What we say is there is a common feature to both cases, both sets of cases, and that is they each have a life. And the protections against enabling somebody to be assisted in dying are huge. Court has to be, well, at the moment it's against the law, but the point is all the debate around that area is about sufficient safeguards being put in place. The whole of Nicklinson was devoted to that issue. And here we are in a situation where, if we're right about the rights that we contend for, there are no protections of any kind. And so we say that is a distinction which is discrimination. And the point is a short one. It's developed, as I say, in our case, but we do say that my learned friend Mr. Sach-Davis is completely wrong to say, well, there's no point of comparison. One's allowed by law, one isn't. Here we're concerned with a life, whether it's a life that an autonomous person wants to invoke to kill himself or a mentally incapacitous person. They are in the same boat as we all are in having a life that needs to be protected. So that takes me past the last question on this Proposition 7, which I'll come to, I see the time, is has the rationale in Bland been removed by the enactment of the MCA? And then I come to Proposition 7.
That clock is fast.
Oh, is it? Well, I'll continue.
Yes, you've got...
If I've got a
well,
few...
by the clock on my machine, you've got another 7 minutes.
Oh, wonderful.
So if you give yourself another six or so.
I think I then can finish Proposition 6. The question here then is, has the rationale in Bland been removed by the enactment of the MCA? And we say that although there is no statutory requirement under the MCA to bring this class of case to court, the common law position for patients in this category, even where there is unanimity of view amongst clinicians and relatives, requires an application to the Court of Protection. Nothing in the MCA regime removes the concerns voiced in F and Bland as far as patient protection for what we say is an especially vulnerable category. We've set out the detail of the MCA regime in our case. I won't repeat it. When considering the factors relevant to best interests under Section 4.6 of the MCA, it's now settled law that the court must look at the question from the point of view, the assumed point of view of the patient. And that's Aintree, paragraph, page 648. But to rely upon a premise that a non-dispute between doctors and relatives will mean that P's point of view is being respected, we say is a fallacy. In cases of withdrawal of CANH, doctors are likely to be highly influenced by the view of family members. In turn, those family members will often be wedded to a particular outcome of the decision at the outset. So without an application to the court, at least under the current conditions, there will be no independent voice from P's perspective. Section 4, subsection 7 of the MCA cannot have been intended to and does not give the family such a determinative voice as the respondent's position entails. The dangers of an unquestioning acceptance of a family's account of P's likely perspective has recently been emphasized by Mr. Justice Hayden in, I don't know how you pronounce this, but I think it's Abatawe Bro Morganweg, Health Board against RY, Authorities 3, tab 19, Memory Stick, page 1075, paragraph 40. And Mr. Justice Hayden there revealed how an experienced independent expert and a High Court judge could be taken in by a family. He said this, paragraph 40, Mr. Badwan had assumed that RY's, well, Mr. Badwan, of course, is a witness in this case, but on the wrong side here, perhaps. Mr. Badwan had assumed that RY's wishes and feelings were clearly and accurately asserted by his family. At an earlier hearing, I'd made the same assumption. For the reasons I've just outlined, we were both wrong. Mr. Badwan told me that if it was the case that RY would not have wanted the proposed medical course, he would regard that as so significant as to be determinative. So if doctors are to confer considerable weight on families' unevidenced views of P's wishes, the need to test the basis for the family's opinion in court is very acute in our submission. And as your ladyship noted in entry, see paragraph 45, memory stick page 648 to 649, it will not always be possible to ascertain what an incapable patient's wishes are. I mean, I certainly take you to that paragraph, but that's exactly what your ladyship said. Mr. Justice Baker has also recognized...
Seems to flatter the blindingly obvious.
Well, I agree. I'm certainly not disputing it. Mr. Justice Baker has also recognized this. See Authorities Bundle 6, tab 57, page 2337. I'm not sure whether I think I may have read that earlier, how family witnesses have, quote, inevitably imperfect recollections of what was said and very probably have their own views and opinions that may consciously or unconsciously influence the account of what was said by P. Furthermore, even, he said, when one can be satisfied that P has indeed written or said what is alleged to have written or said, the most that can be said is represents his wishes and feelings at that point. And then I've already read the dicta of Lady Justice Butler Sloss in Bland, see memory stick page 678. So the risk is, obviously, that the family may import their own opinions and portray them as P's views. And we say that the MCA, when you look at the detail of that regime, can't possibly have taken away or even watered down. It's probably enhanced the rationale of the court of the House of Lords in Bland. It is true, and I accept it, and of course I have to accept a number of, this is a difficult case, but I accept that the type of problem I'm talking about now is not unique to PDOC cases, but that's why Proposition 7 is important. And your ladyship's distinction between important and very special cases is one that I make unashamedly. Even if there were some other cases that fell into the special category, it wouldn't deprive our analysis, we say, of effect. The real point is there a class of case where the question of doubt could be identified by a third party, sort of case that really needs that protection? That's the question. All my propositions are interlocked, so but 7 is important.
7 is the key, is it not?
Yeah.
It seems like a suitable point at which to adjourn, but could I just ask everybody, the Mental Capacity Act was motivated by and largely implemented the report of the Law Commission, number 231 in 1995, on mentally incapacitated adults. That report recommended that these cases be brought to court unless and until the Lord Chancellor, I think it was, then exempted them by order. That recommendation was in the draft bill attached to the report, but it was not, of course, in the Mental Capacity Bill when it was eventually, 9 years later, introduced into Parliament, and it would be good to know why.
Give it thought. Thank you very much.
Well, it's not unimportant, is it? It may need overnight to find out the answer.
It may indeed.
We'll look forward to hearing from you further at 2:00, Mr. Gordon. Court is now adjourned.